On this week's episode of the Crushing Debt Podcast, debt settlement, it ain't poker.
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner, owner and founder of Yesner Law, and I do owe you all an apology right off the bat. If you are a weekly subscriber to the show, you will notice that I did not release an episode last week, and I sincerely apologize for that. I ended up going on vacation. In fact, the episode I did the week that I left was how to save money or how to prepare to go on vacation and not spend a ton of money. And then that Friday I was going to record an episode, but that was the Friday that I ended up leaving. And with the hecticness of trying to get the office under control, emails under control, work projects under control, get packed, get the family packed, get the car loaded and get out, in all that craziness, I just ran out of time to record an episode. I did get back Wednesday, but didn't really have enough time to record an episode to get to my editor to then get out to you on the following Thursday. So for that, I apologize, but sometimes life gets in the way. I try to release weekly, and I figured it was better to just skip a week and come back with some fresh content rather than try to force some kind of content that probably wouldn't have been very valuable to you anyway. So I do apologize for missing a week, but we're back. And the good news is I'm recording this week's episode on Friday like I normally do, and I've already recorded another episode next week. So I have at least got the next 2 weeks recorded in advance, and I'll continue to record so that I'll get a couple weeks in advance for all of you. So I do apologize again. And I've got a good episode for you this week about debt settlement and bluffing and poker and all that kind of stuff. But I do want to mention here real quick right out the gate also about our sponsor, Sam Cohen of Attorneys First Insurance. Now, Sam writes errors and omissions insurance, malpractice coverage, basically professional liability insurance is what it's also called, for attorneys and title companies all over the country. Now, Sam is here in the Tampa Bay area with me, although he can cover all of Florida. I know that he can cover Texas, and he can pretty much cover anywhere in the country. And what I really like about Sam is that it's Sam. And so you're not going to call some 800 number and go through a phone tree, and you're going to call Sam, and Sam's going to pick up the phone. And Sam is very knowledgeable about E&O insurance to the extent that he can tell you apples to apples. What do you have versus what does he offer? And if he doesn't offer something competitive, he's not going to offer it to you at all. He's also very, very honest. And so we very much appreciate Sam's sponsorship here of the Crushing Debt Podcast. We very much appreciate our relationship with Sam Cohen and Attorneys First Insurance. And a great way to support us and a great way to support Sam is to refer him an attorney or title company that you know that's starting up a new business, doing law or title or both, or somebody that's just looking to renew their coverage. And you can reach Sam at his email address, which is sam@attorneysfirst.com, or the website is also attorneysfirst.com. And so what am I talking about today with this topic of debt settlement ain't poker? So I wrote a blog post, 3-4 years ago now, about trying to bluff creditors. And what I said was that, in poker, people bluff when they have a bad hand, hoping the other players can't read their tells and will surrender the chips they've already played, even though they may have the better hand. But here's the problem. In debt settlement, bluffing doesn't really work a lot because the borrower doesn't have the leverage. The lender doesn't necessarily have tells that they can give away. The borrower doesn't even necessarily have tells that they can give away. And if you try bluffing with a creditor in terms of settling debt, it can backfire on you. Now, have I bluffed creditors before? Yes. If you're a creditor and you're listening to this podcast episode, I've never bluffed with you. But have I bluffed with creditors before? Yeah. And debt settlement can be a good option if bankruptcy is a bad option, or if the client just simply doesn't want to file a bankruptcy. Debt settlement is one of these other tools that we can use. Now, what do I mean by debt settlement? In my mind, debt settlement means we're either offering a lump sum payment that is less than the total balance owed, or we're offering some kind of payment plan where we're going to pay some balance over some period of time. So you owe 10 grand to a creditor, we're going to give you a lump sum of $2,500 or $3,000. You owe 10 grand to a creditor, we're going to pay you $500 a month for 10 months, something along those lines. Now, maybe those two can be combined. You owe 10 grand to a creditor, we're going to pay you $2,000 up front, leaving a balance of 8, and we're going to pay $6,000 after that by paying $500 a month for a year. And so at the end, we will have repaid you $8,000 on the 10 that we owe, but we're going to pay it a lump sum up front, and we're going to pay monthly payments going forward. And so any of those things can really be used to settle debt if the creditor accepts. So what do I mean by this ain't poker? Well, convincing the creditor to take less than what's owed requires some skill. It may require a little bit of bluffing, but a majority of the time, full disclosure is the more effective technique than withholding information. If I've got the winning hand, contrary to what I might do in poker, I'm going to tell the world, and I'm going to tell them often, and I'm going to tell them with conviction. Now, I've made the analogy before that debt negotiation is not criminal law. What I mean by that is there is no such thing as innocent until proven guilty or unable to pay until you've proven an ability to pay. That doesn't exist. It's not a crime to fail to repay your debts. That's okay. And there is no such thing anymore as debtor prison, so you don't have to worry about that. But what I mean is there is no assumption that you can or cannot. In fact, if there is an assumption at all, the creditors think you can pay back your debt until you prove to them that you can't. So again, if you've got the facts to show that you can't repay the debt, you need to show the creditors that information. Debt collectors can do a lot of things to try to get the money that's owed. They can repossess assets. They can garnish wages. They can levy against bank accounts until the borrower proves that those assets are exempt or maybe over encumbered by debt or just simply not worth pursuing. One thing that I don't like to do is threaten, because the debt collectors have heard it all before. So they're really unlikely to be swayed by any emotional type argument. Now, we may bring that in if the borrower has some kind of disability or if there's some family situation. Although in my experience lately, creditors have been tired of hearing about COVID for whatever reason. So I'm less and less using COVID as the reason why payments fell behind. Plus, as I record this in February of 2022, we're almost now 2 full years since the outbreak of COVID. And while COVID is very much still with us, and we hope we're getting near the end of it, a lot of the economy shut down and job loss and a lot of that kind of stuff happened 2 years ago. Now, granted, a lot of it is continuing today, and it is still impacting the economy today. But I don't think COVID is impacting the economy today as much as it was when it first materialized, I guess, in 2020, at the beginning of 2020. So, we need to disclose the nature of the assets, even though that might reveal the assets' existence to the creditor. But we can also then show the creditor that those assets are protected, they're unavailable for collection, or they're just simply not worth pursuing. A lot of people don't like to tell the creditor that they have a 401k because they think the creditor will insist that they invade the 401k to pay back the creditor. And while the creditor may insist upon that, the creditor can't force the issue. The creditor cannot force you to cash in a 401k. 401ks are exempt. Now, inherited IRAs may not be exempt, inherited IRAs. But an IRA that you've established or a 401k that you've established, those are totally exempt. The creditor can't touch them. I also had a client tell me, I have many clients tell me, that they don't want to provide their spouse's information for fear that the creditor will pursue the spouse for collection. Now, while I respect the decision, and I have to do what you tell me because you're the client and I'm the attorney, I think it's the wrong decision for a couple of reasons. First, in this particular example, the spouse had no obligation to the creditor. The spouse didn't sign the loan agreement. The spouse didn't sign the credit card agreement. And so the spouse really had no liability to the creditor. So providing the spouse's information posed no danger to the assets owned individually by the spouse. The creditor could not pursue that spouse for any reason. Providing the spouse's information would have been as dangerous as providing my information to the creditor. In other words, it would have had no impact. If I sent my bank statements to the creditor's not really going to care because I don't owe the creditor the debt. Same thing in this example with the spouse. The spouse didn't owe the creditor money, so sending information about the spouse to the creditor would have only proven that the client was uncollectible. The ultimate debtor, the spouse that did owe the money, was uncollectible. The second issue here, in this case, the spouse was unemployed. And so providing her information to the creditor, providing the unemployed spouse's information to the creditor, actually would have proven the opposite. In Florida law, under Florida law, there's something called the head of household exemption. And the head of household exemption is for the spouse that provides more than 50% of the support of dependents. And so if you've got one spouse who's working and one spouse who's totally unemployed, the spouse who's working is the head of household. They provide 100% of the support of the dependents, especially in a situation where the other spouse doesn't work. And so providing the creditor information about the unemployed spouse only proves that the employed spouse, the one that owed the money, is uncollectible by wage garnishment as being head of household. So in that scenario, I think the information should have been provided, but the client didn't want to do it. Now, ultimately, I think we resolved that case, but it was a little bit more difficult because the client refused to provide information that would have made my job to settle the debt much, much easier. So here's the other thing that happens. If the bank sues and gets a judgment against you, a lot of times here in Florida, the creditor will put in the order that the borrower, the debtor, the defendant, has to provide a Florida fact information sheet. Now, if you don't know what this is, let me know. I can send you the form. I think it's form 1.977 under the Florida Rules of Civil Procedure for those of you that want to look that stuff up. But basically, the fact information sheet provides information to the bank in terms of what's the borrower's legal name, what are their aliases, where do they live, do they own where they live, or do they rent where they live, where are they employed, what's their rate of pay, what's their commission structure, what's their social security number, driver's license number, what's their marital status, what's their spouse's employment status if their spouse is employed or if they're married. What about children or other dependents that live with you, real estate that you own, motor vehicles that you own? Those are the types of things that are requested in a fact information sheet. The failure to provide that fact information sheet could eventually become an issue of contempt. The court could hold you in contempt for failing to provide that fact information sheet. And if you're held in contempt by the court, some of the sanctions could be fines, and in really egregious cases could be jail time. And so the irony here is that providing the fact information sheet could assist us in the settlement of the debt and in some cases cause the creditor to drop collection activities entirely because the fact information sheet, if answered honestly, shows the creditor that there's nothing there worth pursuing. The creditor may simply go away. I remember one client we had who the creditor got a judgment and wanted the fact information sheet and was pursuing motions in court to get the client held in contempt until the client would return the fact information sheet. And so I sat down with the client and I went over the information in the fact information sheet, and here's what I learned. This was during the time of the Great Recession or right after the Great Recession, and the client was a realtor, full-time, meaning the client had no money, had very little listings, not much was going on. So they're a realtor right after the Great Recession. They had no pending listings. They had no IRA. They had no 401k. They had no savings. They had a couple of $100 money in the bank. They were unable to find employment. So we submitted all these facts to the creditor, and the creditor just simply went away. Now, one thing we did bluff was that the client lived with his significant other who was taking care of all the expenses. And so it wasn't like the client was totally destitute, but This was a same-sex couple who at the time, marriage was not yet legal in Florida, and so they were not married. And so all the places on the fact information sheet where it said spouse's information, we could properly say NA because the client was not married. Now, in that limited situation, I think bluffing was okay, and we didn't lie, and we didn't lie by omission, and we did tell the truth. And so in that scenario, I think the bluffing was okay because the information that we did provide was 100% truthful and 100% accurate. The interesting thing about that is that after providing the fact information sheet, which was now like 7-8 years ago is when this case happened, we haven't heard from the creditor since. It's been 7-8 years. We haven't heard from this creditor at all. Now, keep in mind, if a judgment is entered against you or entered against someone in Florida, that judgment, once entered, is good for 20 years. So it's possible if the judgment was entered 7-8 years ago, we've still got another 12 or 13 years before the judgment totally goes away. But since we haven't heard from anybody in the last 7-8 years or so, the chances of hearing from them again are slim to none. And for confidentiality purposes, I'm not going to say the client's name. I don't think the creditors really listen to this show, but on the off chance that they do, I'm not going to say the client's name. So good result for that client, but it arose from mostly telling the truth and a little bit of bluffing. So we went through what's in the fact information sheet, and we went through a situation where I could bluff, but a lot of times if the facts are there, if I've got the hand, I'm going to show the creditor that I've got the hand. So, again, I would never endorse or recommend lying to the creditor on the fact information sheet because it is prepared under penalty of perjury. It is signed under penalty of perjury, so you don't even want to, quote, lie by omission. However, presenting the information in such a way that the creditor sees that the borrower has exempt assets or no assets or upside-down assets or invaluable assets will go a long way towards a quick and easy settlement. And if the information is provided at the outset, that makes settlement even faster. What's some other information that you might want to show to a creditor to show that you're, quote, uncollectible, meaning you've got nothing available? In other words, you can't get blood from a stone. You don't have anything to take. I've got nothing, creditor. You can have it all, kind of a concept. Well, some things that we can also show the creditor. 3 to 6 months of bank statements. If the bank statements show more money going out than coming in, or if the bank statements show a break even every month, stuff like that. 2 years of tax returns, business profit and loss statements, pay stubs, proof of other debts or judgments you have. I have one client right now. We have, I think, 5 or 6 different creditors that we've settled with, and more debt keeps coming up. This client refuses to file bankruptcy for some reason. And so every time I get a new creditor, I send that creditor proof of the other settlements that we have and say, do you want to be the tipping point that pushes her into a bankruptcy? And a lot of times that allows us to get that one settled. Now, here's the other thing. If you do end up getting garnished, the maximum garnishment is 25%. Now, it's 25% of gross. So if you get $1,000 in your paycheck, they can garnish $250 gross. You still have to pay tax on the $1,000 and anything else that's withheld. So your paycheck will really go down by $250 in that scenario. But once that 25% limit is reached, no other creditor can garnish. So if you've got 3 or 4 creditors chasing you and that first one garnishes 25%, no other creditor can garnish until that first one is paid off in full. And so sometimes that's something that we can show to creditors. Hey, we want to settle this one because we're already being garnished by that creditor, and so you can't garnish even if you want to until creditor number 1 is paid off. And based on the garnishment, creditor number 1 isn't going to be paid off until I'm 150 years old. So do you want to settle now, Mr. Creditor, or do you want to wait until I'm 150 to put your garnishment in place? Other things you might want to send the creditor to show that you're not collectible: proof of any alimony or child support that you have to pay, and even a hardship letter. Now, I don't know that hardship letters are really persuasive, but it can't hurt to write one, and it can't hurt to have one in the file. What you want to do, though, is avoid things that are of your choosing. So things like I took a pay cut at my job, things like my house has dropped in value, things like my stocks have dropped in value. You want to focus on things that are outside of your control. I lost my job. I got sick. I lost my spouse and my income got cut in half as a result. You want to focus on those things that show that your drop in income was uncontrollable and nothing that you caused or contributed to. So now what happens, let's go the other way. What happens if you have assets and the creditor maybe finds out about those assets, or you're afraid that the creditor is going to find out about those assets? Well, Florida has a couple of exemptions. Or if you want to think about it this way, exemptions are protections. So what can we protect? Well, again, I've already talked about the wages of the head of household. Those are protected. Life insurance policies are exempt. Annuity contracts are exempt. Disability income is exempt. Social Security income is exempt. IRAs, 401ks, and other retirement accounts are exempt. Now, there is an exclusion there if the retirement account is an inherited account, but accounts that are not inherited are exempt. Money in a qualified tuition program is exempt. Money in a medical savings account or similar programs are exempt. You get a generic $1,000 wild card exemption to use on anything you want. You get a $1,000 exemption towards the equity in your car. All of these things are protected under Florida law. Now, that's not everything. Florida has a whole bunch of other exemptions. So if you're curious, what are my exemptions? Give me a buzz, shoot me an email. You can contact me at sean@yesnerlaw.com. Contact a local attorney if you're not here in the Tampa Bay area. Certainly if you're outside of the state of Florida, contact a local attorney because exemptions differ from state to state. And so I don't want to tell you something's exempt here in Florida that may not be exempt somewhere else. Again, equity in your homestead. That's one of those things that in Florida, equity in your homestead, your primary residence, is 100% exempt, but not all states agree. So depending on where you live, the equity you have in your home may not be 100% protected. So again, talk to me, talk to local attorney, find out what protections you have. Sometimes too, and I've said this a couple times on the show, and I've said this to a couple of clients as well. If you are uncollectible and you have what I call a thick skin, you could potentially do nothing. Or that could be your basis for settlement. That could be your leverage for settlement with the creditor. Now, what do I mean by uncollectible and thick skin? I met with a client yesterday who was elderly on Social Security income, which again is exempt, had no other income coming in, owned their home, which again is 100% exempt, but it was a small home, 800, 900 square feet, didn't have many assets of any value, didn't own their own business, didn't have any expensive jewelry, didn't have a lot of money in the bank. Any money that was in the bank was as a result of Social Security. So again, that was exempt. In other words, this person had nothing that was available for collection. And so if you have a thick skin, because what happens is when you fall behind with your creditors, you start with the phone calls. And then when the phone calls stop, or even maybe the phone calls don't stop, you then get served with lawsuits, and you may get judgments against you, and you may get people asking you to fill out the fact information sheet. But if you have nothing that the creditors can take, that's the worst that's going to happen, is you're going to get some phone calls and you're going to get some court papers. But ultimately, nobody's going to be able to take your stuff. Now, if you're worried about it, then maybe a bankruptcy or a debt settlement or something like that is more appropriate, just to make sure we know that the creditor is going to stop calling. But if you don't have the assets, either explain that to the creditor or have a thick enough skin that it's not going to bother you when they try to collect. That's another option that we can use maybe to help settle debts, avoid debts, whatever. Now, here's the last thing that I want to say. For debt settlement to be an effective strategy, the client has to have some money saved up that they can use to settle with creditors. I am not the type of company. I'm a law firm. I'm not a debt settlement company. Let me say that again. I am a lawyer that owns a law firm. I am not a debt settlement company. So I am never going to tell you, pay me every month, and when we accumulate a certain amount, I'm going to pay the creditor. That's not going to happen. You're going to be the one to save up money every month. And when you have an amount saved up, maybe then we can call the creditor and try to settle this on a lump sum payment. Or instead of you saving up money every month, let's offer that money as a monthly payment to the creditor as part of a settlement. Or again, like I said at the beginning, combine the two strategies where we offer them a little bit of money up front and then some monthly payment until some portion of the debt is paid. But I'm not going to collect any money from you in terms of a monthly savings account or escrow account or anything like that. Certainly I get paid a fee up front. And then I also get paid a fee based on how much money I save you in my negotiations. But aside from that, you're only going to pay me at the outset when we take on the case. You're going to pay me when the creditor agrees to a settlement, or you're going to pay the creditor when they agree to a settlement. And that's it. But again, in order for debt settlement to be an effective strategy, you have to have money saved up, or you have to have the ability to save money up. But I think the point that I really wanted to drive across is the title of this week's episode. Debt settlement ain't poker. Don't try to bluff the creditor. If you've got the goods, if you've got the hand, show the creditor that. If you're uncollectible, show the creditor that. If you don't have the ability to pay, show the creditor that. And if you could do those kinds of things, we can get these debts settled for a lot less than what you owe, or maybe even on rare occasion, get the creditor to go away completely. So that'll do it for this week's episode of the Crushing Debt Podcast. Again, I am back. I'm getting ahead in episodes, so I'll have a bank of episodes here that I can produce and distribute weekly for you all. Again, I apologize for missing last week, but frankly, taking a vacation, not only from work, but taking a vacation from family, taking a vacation from the podcast, also recharge my batteries a little bit. Let me refocus and think about some of the topics that I want to talk about and bring to you so that I am constantly creating value for you. If you missed last week's episode, I really do apologize for that, and I will continue to produce weekly content from here forward. So that'll do it for this week's episode. I hope you enjoyed it. I hope that at the end of the month you have more money, rather than at the end of the money you have more month. Again, that'll do it, and we will talk to you in next week's episode of the Crushing Debt Podcast.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.